right, well, I think we're going to get started. We have a few that joined in. I want to say hello for everyone that has joined in for Title Talk Live. I'm with one of our star underwriters this morning, Jerry Grand.
Nice to be here.
Yes, all right. Well, just a reminder, a few things. Title Talk Live is aired every Thursday at 10 a.m. And we talk about everything that's related to a title agency. So it can be on leadership, could be on sales, could be on underwriting. If there's anything of interest that you'd like us to speak on, I'd certainly encourage you to, you can send me an email, or actually you can just send us a little Facebook, just let us know. This show is aired every week, Thursdays at 10 a.m. We're also going to have a drawing at the end, so if you joined in, there again, let us know that you're here. We want to know that you're here, and you'll have an opportunity to win a prize at the end. So with that, I introduced Jerry earlier. So Jerry, just tell us something a little about yourself. For those, I'm sure that many of you know who Jerry is, but Jerry, why don't you tell us a little about something?
I'm an underwriter for Fidelity National Title Group. I've been an underwriter for Fidelity since 2003.
Wow.
And I underwrite for Tennessee, Alabama, Arkansas, and Mississippi. So I guess that's really about it. I guess at one point I was a state underwriter for Arkansas and Mississippi. I'm still the state underwriter for Alabama. So I cover a broad amount of territory, whatever. And I happen to like talking about the bankruptcy code or whatever. When I was in private practice, I actually represented clients, both debtors and creditors, in bankruptcy court.
Wow.
And also in bankruptcy litigation. So again, I kind of enjoy talking about it, and I'm not sure all the other underwriters do enjoy it so much. So I'm glad to be with everybody today, and I'm going to try to increase everybody's knowledge a little bit about the bankruptcy code.
Yeah, and I asked you earlier, this was off air, but I asked you, ranking 1 to 3 as far as the underwriting calls that you get, like the type, and I think that you said estates would be on number 1.
Right.
Where would this fall, I guess? Just
This probably falls within maybe the top, certainly within the top 10, maybe the top 5. Most of the questions come up having to do when you've got a buyer who has recently or at some time been in bankruptcy, or you've got a seller who's currently in bankruptcy.
Okay.
And the question always is, who can sign the deed? What needs to be done in order for that seller to go ahead and sell that property? And can we give them the money, and those kinds of questions? So
okay.
There's a lot of bankruptcy questions having to do when you've got a seller who's in bankruptcy and is in the process of trying to sell the property they own.
So it would definitely be considered one of the top.
I think it is, yeah. I think
underwriting questions.
I think it is, because most people are not too comfortable when there's a bankruptcy issue, and a lot of times the seller's not sure what they've done, and sometimes maybe the attorney representing the debtor in bankruptcy is not really a real estate person, and they maybe don't understand some of the requirements that we're going to have.
All right. Well, real quick, can you just talk about the different types?
Sure. The bankruptcy code is divided into chapters, and each of the cases is based upon the chapter that it's in when it's filed. So a Chapter 7 bankruptcy is a liquidation bankruptcy, and that's more the classic type of bankruptcy where the person files bankruptcy, the court appoints a trustee to represent the unsecured creditors, and you go through the whole bankruptcy process. There's no intent by the debtor that's filed bankruptcy to really pay anybody.
Okay.
If they want to keep their house and their car, their automobile, they normally are going to reaffirm the debt with that creditor in order so they can keep their house, keep their automobile. As the process goes on, at some point they're going to receive a discharge of those debts that were listed in their bankruptcy schedules. The thing I always want to point out to people, and it's important to remember, is the fact that the debt has been discharged doesn't eliminate the debt. In effect, all it does is basically forgive them forgive the debt as far as the repayment of the debt. So the debt's still there. It's just the requirement to repay it has gone away because of the discharge. Now sometimes people think, well, my debt was discharged in bankruptcy and therefore it's eliminated. When in effect, it's not eliminated. It's just there's no requirement that you pay it. Occasionally people who have debts that are discharged in bankruptcy, sometime later on after the discharge, they go ahead and pay that debt in order to establish some sort of credit relationship with one of the lenders they may have, like a local bank or whatever. They may go ahead and agree to pay a debt that's discharged. The lender can't take any sort of action to collect the debt, but it doesn't stop the person from voluntarily paying it if they want to. The next chapter that we see most frequently is a chapter 13, and that's basically like a situation where a person has regular income and they want to file bankruptcy in order to pay some percentage of their debts, but maybe not 100%. So they file a chapter 13 bankruptcy, provide a chapter 13 plan in which they establish the fact they're going to pay some percent, 100% down to some smaller, maybe 50% of the debt or whatever. And generally it applies to unsecured creditors. If you have missed mortgage payments, you can put the missed mortgage payments in your Chapter 13 plan, but then you have to continue to make your regular mortgage payments timely. Same situation with like car payments or whatever. You can put some missed payments in your Chapter 13 plan, but you have to continue with the regular payments, or they're going to come, repossess your car after they get a lift stay. The trustee in a Chapter 13 is considered a standing trustee. It's the same trustee that the bankruptcy court uses, and that trustee collects the money from the employer, however the money's being paid, and then they distribute those funds to your creditors. When you finish the plan can go from either a minimum 3 years to 5 years. Once you've completed the plan, then you're going to get a discharge of those debts, even though you didn't pay maybe 100 cents on a dollar for them. So that's a Chapter 13 wage earner type plan. Now there's a test to see whether or not you can actually file Chapter 7, and they go through a process, and if they don't consider the fact that your debts are so serious or so high and your ability to pay is so restrictive that you are going to be allowed to file a Chapter 7. In other cases, you're going to have to file a Chapter 13 and you're going to have to pay something back to your creditors. So we see a lot more Chapter 13s maybe now than we have in years past. And I guess then the final one that we see fairly often would be a Chapter 11, which is a reorganization bankruptcy. And you hear about Chapter 11s often with large companies. Sometimes companies stay in Chapter 11 for years and years, and they come out of Chapter 11, and then they file a new Chapter 11. So it's not something we normally see with individuals, although I guess there have been instances where individuals have filed a Chapter 11. In a Chapter 11 bankruptcy, you're going to propose a plan to pay your creditors, and in most cases, because it's an ongoing business, they don't appoint a trustee unless it's necessary. They allow the debtor who's in possession of the property to continue to operate their business, and then when a plan is approved, they go forward with that plan. Sometimes the plan involves either canceling contracts or canceling leases, or liquidating some of your assets or properties, being able to find a new lender to maybe refinance some of your debts. So we don't see a lot of Chapter 11s, but if it's a business who owns property and they're in Chapter 11 and they're getting ready to sell some of the property, then we are going to get an underwriting call about it.
Interesting. So what type of calls do you guys get, underwriters get, if the seller is involved?
Generally, if it's a seller who has filed Chapter 7, what we look for is to see if the trustee has abandoned their interest in the property, okay, or has filed a no asset report. Once they abandon their interest in the trustee's interest in the property, then the debtor would have the ability to sell their property then that's not a problem.
Okay.
Aside from that, I guess, in some cases, if there's like sufficient equity in the property, the trustee themselves may decide to sell it. And although I guess all your property kind of it belongs to the trustee when you file a Chapter 7 bankruptcy, they can't really sell your property without getting a court order. So they have to get a court order to sell it. You can certainly fight about whether or not there's sufficient equity. You have a homestead exemption you can claim. But the thing to remember when you're a title agent, in fact, normally the Chapter 7 trustee is going to want to pay all the lien creditors on the property.
Okay.
So they're going to want the ability to receive the funds, the proceeds from all the proceeds from the sale, and then make those payoffs for judgment liens or deeds of trust, and that is sometimes makes it difficult for us. So if you have one like that where the trustee's selling, call an underwriter about it. The other instance is when a debtor in Chapter 13 wants to sell their property. The Bankruptcy Code says that a confirmed Chapter 13 plan vests the title to real estate back in the debtor, but the plan that's usually confirmed, especially in our area, almost always has some kind of restrictions on them selling their real estate. It may state that the real estate's going to remain part of the bankruptcy estate until the plan's complete. So in most cases, then you're going to have to get a court order to allow the person to sell their property when they're in Chapter 13. Chapter 11, a lot of times the plan itself will provide, a plan that's approved by the court will provide the fact that the debtor is allowed to sell assets. In that case, if there's a confirmed Chapter 11 plan and the plan provides that the debtor can sell whatever they're building, their house, their property or whatever, then that's sufficient. We probably are going to require the fact that any sort of court order regarding it or the plan to be recorded in the registrar's office to put people on notice. But there are other bankruptcy chapters we're not going to talk about. Chapter 9 is where a municipality files bankruptcy. I've never had that question ever come up. There's also Chapter 12 bankruptcies, which are farmer bankruptcies. We don't hardly ever see those. I can't remember the last one I've seen of those. It's kind of a hybrid between Chapter 11 and a Chapter 13. If you have a Chapter 12, it's similar as far as the plan, the debtor's plan or whatever, but I think you'll probably want to give us a call if somebody's in Chapter 12 bankruptcy and they're trying to sell their farm or a portion of their farm.
Yeah. And just real quick, I want to say a shout out to Annette, Melinda, and Jamie. I see that you guys have shouted out to us, so I just want to say hello. Well, Jerry, what happens to a judgment lien that is against a buyer or seller that has a discharge?
Yeah, that comes up very frequently where the buyer has been in bankruptcy and they've had the debt for the lien discharged. So the thing to remember is if it's a judgment lien that's recorded before they file bankruptcy and the debt of that lien is discharged in bankruptcy, then that lien will not attach to property that they purchase after the discharge. As far as a seller, a lot of times sellers believe that because the debt was discharged, the lien goes away, and that's not necessarily the case. The lien has to be avoided, or there has to be some sort of court order avoiding the lien. So if you are the seller and you have a judgment lien that's recorded before you file bankruptcy, just the fact that the debt's discharged doesn't make that lien go away as to property that you owned at the time you filed bankruptcy.
Wow. Was this guy a wealth of information or what? Well, Jerry, we want to thank you for joining our show this morning.
Thanks.
Thank you, everyone, for joining Title Talk Live. Just real quick, I did want to say that I got a pick from my assistant. Annette Cherry won the $25. Marty, hello, good to see you. Thank you for shouting out to us this morning. Annette won the $25 gift card to Starbucks. So Annette, enjoy that. But thanks to everyone else for joining Title Talk Live. We will see you same time, same day next week. Thank you.
Thanks.
Bye.
Bye.